Hello.
Hello.
Can you see the slides?
No.
The slides were showing briefly before, but now they're gone.
Okay.
Now?
Yes.
Okay. We're going to wait a couple of minutes. We actually have quite a few people signed up for this, so we'll let folks get a chance to sign on.
Yeah.
I'd ask if everyone can mute your mics
Yeah.
unless you're asking a question. That would be great. I'm going to wait about another 4 minutes to get started to give people a chance to get online. But in the meantime, does anybody have any question or issue about either homeschooling, home hospital tutoring, or homebound IEPs that you want to throw out at the outset? And I'll try to respond to that as I'm going through the presentation. Nope. Hi, Luca.
Hey, Matt.
Okay, I think that we will jump into this now. I see there are a couple of questions just at the outset. Okay, I was wondering about why there were 3 Janets online. Oh. Okay, and I've got an interesting question from Melissa. I'll try to get to that in the context of things, but if I'm not seeming to get to it, Melissa, please go ahead and remind me of that as we're getting into the home hospital section. Okay, so I'd like to begin. First, I want to I'm Matt Cohen, and I'm the founder of Matt Cohen and Associates. This was initially billed as a presentation that I was going to do in conjunction with Brad Dems, who some of you may know. Brad had a a child recently, and he's decided to go to become a full-time parent for the time being. So he's not currently working, and we wish him well, but as a result, I'm going to be doing this presentation solo. So those of you who know Brad, feel free to send greetings, but he won't be involved today. And those of you who've been working with him on other things, we're just sliding his work over to other people in the office. But I'm going to jump into this. We were scheduled to do this through 1 o'clock. I am open to questions as we go, but we have a lot of material to cover. So I may be able to respond to your question in the moment, or I may tell you that I need to wait until the end or have you email me, and I'll be happy to respond at that point. There is background noise from at least some speakers, some person in the audience. So if you can please mute your mic when you're not asking a question. I think it's Robin Simpson. There we go. Thank you, Robin. And so this topic is a very important topic. It's covered by the Illinois School Code. It's covered by a variety of Illinois regulations, and some parts of it are covered by federal law. But it's an area that there is a lot of confusion about. And the important thing to understand at the outset is that there are multiple different circumstances where a child may be eligible to be educated at home. And there are multiple different implications to how that home education is set up. So just by way of an introductory summary, one way that kids can be educated at home is through what's called homeschooling. And we'll get into that in detail in just a minute, but that's a situation where the parent just decides they don't want to send their kid to public school anymore, and they're going to educate them at home in whatever format and for whatever reason that they want. And that is an absolutely protected right in Illinois. And as you'll see from the material that I'll be sharing in the next few minutes, it's generally speaking a pretty unregulated area. So in homeschooling, you can take your kid out of public school, you can educate them yourself or in some other fashion, but generally speaking, you don't qualify for services from the public school if you're doing that. The second category of services for which kids can qualify if their parents don't feel they're wanting them to attend school or can't attend school. Actually, it only fits if they can't attend school. Is if a child has a medical reason that they can't attend school for more than 10 days, either sequentially or cumulatively, the parent can, with medical certification, be eligible for the child to receive what's called homebound tutoring. And that's tutoring provided by the school district that's typically provided in the family's home, and we'll be talking about that. And that's applicable whether a child is a regular ed student and they break their leg or get pneumonia, or it's a child with a disability who's not able to attend school because of their disability. But in either event, that's not a special ed service, it's a general education service, and there is an entitlement to a minimum amount of services in that situation. The third option, which we'll be talking about and in more detail, is what's called a homebound IEP. And that's a situation where the child is unable to attend school because of their disability, or one of their disabilities at least, and their placement is actually changed to be at home. And so the IEP is modified, and then we'll talk about what services the student is entitled to when they get a homebound IEP. And that has some very strong advantages to it. And it also has some disadvantages and is sometimes misused. So we'll be covering all of that. Homeschooling in Illinois is based on a parent just deciding that they don't want to send their child to school anymore. There is technically a guideline that instruction should be provided in the following subject areas: language arts, math, biology, physical science, social science, fine arts, physical development, and health. But there are no provisions for regulation of that. There's no one monitoring that. There are no requirements for how many days of instruction a week, what specific classes, testing, graduation, state assessment, or anything else. So the parent has enormous latitude to decide to educate their child at home. The major drawback to home instruction, if you're not being very careful about what the content of your child's homeschool instruction is, both if you decide to re-enroll your child in the public school, your child may not be given credit for the educational activities that they were doing while they were in homeschool. And related to that, and pretty obviously, as a consequence, if your child is, you're wanting your child to graduate from high school, the things that they've done while at homeschool may or may not, but oftentimes will not count towards the credit requirements to graduate with a diploma, and they may have to go through some either alternative educational process to get those credits, or they may have to get a GED in order to get a high school diploma. So there's a huge advantage in homeschooling and flexibility, but a huge disadvantage in terms of the issue of how credit is calculated and what you're entitled to. In order to set up a homeschooling program, you don't have to register with your school district or the state, though there is a mechanism for parents to submit a voluntary notice of intention to homeschool with the Regional Office of Education. All school districts in Illinois belong to regional offices of education. I don't remember exactly how many there are, but they're like 6 or 8 of them, maybe 10. So you have an option to do that, but you're not required to. Chicago Public Schools also has a notice that can be completed, a form that indicates an intent to homeschool. The only reason that that's useful is that it helps to alleviate any concern that the school might raise that the child is truant and any hassles that the parent might get in relation to the child not being at school and therefore triggering truancy requirements. It is telling that since the pandemic, and I didn't copy the slide, but there's been a tremendous increase in the rate of absenteeism from public schools and an increase in the number of families who are just opting to homeschool their children because they found it actually worked better than public schools. So that's a growing phenomenon, and that has obviously implications for the quality of education that the child's receiving, which may vary considerably from child to child and family to family. It also has implications because when children are withdrawn from public school, the public school is no longer eligible for funding from the state to pay for that child's education. So their overall budget reimbursement from the state goes down. Illinois does not require school districts to provide resources or materials to assist families in providing homeschooling to their students. So basically, the school can decide to cooperate, but they're not required to. Families should assume that they're on their own. And Illinois law classifies homeschooled students as if they were attending a private school. So basically, goodbye, you're no longer the responsibility of the public school. We're done with you. If a student is a student with a disability, and they either attend homeschool or a private school voluntarily by their parents' decision, they're not entitled to IEP services from the public school. They're not entitled to any educational services from the public school. But there is a provision in federal law that sets up something called an individual services plan. And so parents sometimes get confused because if a child resides in the school district or is attending a private school in the school district has an obligation to evaluate the child to determine if they're eligible for an IEP. And they can propose an IEP for the student to be provided in the public school, but they're not obligated to provide public school services through an IEP to the student who's either in the private school or at home. Instead, the public school is required to provide a certain amount of service to somebody in the public school geographic catchment area that is equal to in cost the number of kids who have disabilities who are being homeschooled or private schooled as a percentage of the total kids who have disabilities in the district. And then the public schools are required to allocate that percentage of the federal funds that the school district receives. So let's say that there are 10 kids who are homeschooled or private schooled in the district with disabilities. There are 90 kids with IEPs attending public schools, a total of 100 kids, 10% of them are homeschooled. The school district would be required to allocate 10% of the funds that they receive from the federal government, not their total special ed budget, but just the funds that they receive from the federal government to pay for some form of service for homeschool that would be delivered through individual service plans. But it could be things like, we're going to provide an LD teacher to do consult with 4 private schools that are located in the district. We're going to offer any kids in the district who are at home or in private school speech therapy or OT or social work, but they're not required to provide a full-blown IEP. As I mentioned, the school does have an obligation to engage in evaluation or child find. And then the only place where the parent really has any input into what the school must do for a child who has a disability who's homeschooled or in private school is they're required to conduct what are called timely and meaningful consultation meetings that they periodically convene with representatives of the private schools and parents who may be in the private schools or may be homeschooled to discuss how the public school might use what are called proportionate share dollars and to have input into the school district's decision on the use of proportionate share dollars. But input isn't control. The public school retains the right to make those decisions, and there's no appeal right if the parents or the private schools disagree with how the public school is choosing to use the proportionate share dollars. So for better or worse, although there's a right to a very limited amount of service to some kids who are in private or homeschooling, it's not child specific and it's not particularly robust in terms of what can be provided, nor is there any way to fight what the school district decides to offer. Schools provide that private school students or homeschool students with disabilities may attend public school on a part-time basis, but that's at the convenience of the public school and their schedule. So there's no obligation that the child, for example, who's homeschooled or in a private school can come at the time that's convenient to the child or the parent. The school district can offer services in the middle of the day, even if that's going to be most disruptive to the child and their other non-public educational program. And there's no requirement that the school district provide related services to students who are being homeschooled with an individual service plan. So very limited rights in terms of special ed services. I mentioned no right to file a state complaint, no right to request a due process hearing relating to a individual services plan for a child who's homeschooled or in a private school. But just to be clear, establishes that there are no very specific standards for how you assess the quality of homeschooling, even though this was a case where this did go to court in relation to school attendance laws. Since then, essentially, as long as you're indicating that you're homeschooled, you should not be having a problem with truancy or attendance issues. It is a choice, and the choice does include the decision to forego special education services and basically waive your right to services from the public school. Okay. Then there's this category of kids who are home for a medical reason with the requirement that the student is hospitalized or homebound due to a medical condition for a total of 10 days sequentially, or it's anticipated that the student is going to miss 10 days or more in a given calendar year. And it doesn't have to be all at once. It can be scattered around as long as there is a medical condition that it's anticipated will cumulatively amount to more than 10 days of absence, as long as the absences are in increments of at least 2 days and meet the total of 10 days of absence. So any student who's going to be absent can qualify for home hospital, except that there is a requirement for documentation indicating that there is a medical reason. The documentation has to be provided by a medical professional, which can include a doctor, a physician assistant, or an advanced practice registered nurse. And they have to indicate the diagnosis, the impact of the diagnosis in terms of the projection of days missed and the need for homeschooling. Once that's provided, the homeschooling is supposed to start no later than 5 days after the documentation is received. Chicago does use its own form for documentation. And in fact, Chicago has a separate form for medical conditions and a different form for kids who are being homeschooled for psychiatric reasons. So be aware that you have to be sure that you have the right type of doctor and document if you're seeking home hospital services within CPS. The documentation must be provided at least annually, and some schools require that it be provided more often, but at least annually and typically every calendar year. And by the way, it's not entirely clear whether the school district has a right to challenge the documentation of the private doctor, but we have had cases where the school district has refused to accept the private documentation because they felt that there was an inadequate explanation for why the child's medical condition prevented them from going to school and why they were going to be out for more than 10 days. And we had to go back and forth and fight with the district. But typically what we were able to do was to narrow down what it was that the school district was insisting on as adequate documentation. And then as long as the medical professional was cooperating, we were able to get more specific and detailed documentation that satisfied that need. And then the kid was able to get tutoring. Under the Illinois Home Hospital Instruction Law, the school district is required to provide a minimum of 5 hours a day. 1 hour a day or equivalent to 5 hours a week of services, unless the medical statement says it can be less or needs to be less. But to be clear, in Illinois, my experience is that most school districts interpret the 5 hour a day minimum as being a 5 hour a day ceiling, and they're only willing to provide 5 hours of instruction. It should be understood that this law does not cap instruction at 5 hours. It just says that the minimum should be 5 hours. It should be during the regular school day unless otherwise agreed upon. And it has to be provided either by a appropriately credentialed licensed teacher in Illinois or by a substitute teacher under the supervision of a licensed teacher. This is an important thing to be aware of, that schools are allowed to ask the parents for a release of information to be able to talk to the doctor about why the child is ill and unable to attend school. But that's only with the consent of the parent. And this is something I hadn't noticed before, but the district may not withhold home hospital instruction while awaiting parental release. That seems to me to be a very important provision that gives the parent the ability to, in effect, insist that the school district provide the home hospital instruction, even if the school district is not satisfied with the medical documentation that's provided by the parent. School districts are not required. I should back up and say, sometimes when a child is hospitalized, the hospital has its own educational staff, and they offer to provide hospital-based educational services for kids who are going to be in the hospital for whatever period of time, but particularly for 10 days or more. School districts are not required to accept the services provided by the hospital, but the fact that the hospital is offering their own educational program doesn't exempt the school from the obligation to provide educational services. So in that instance, they either have to pay the hospital for the hospital's tutoring if the hospital is intending to charge for it, or they have to send in their own tutors to provide the instruction directly and bypass the instruction that's being offered by the hospital. But the fact that the child's in the hospital doesn't mean that they're not entitled to homebound services, home hospital services, unless there's a medical reason that they can't participate. Also useful to know that homebound instruction can be provided for young women who are pregnant, and specifically can be provided to kids both during pregnancy, before the birth of the child, if the child's unable to attend school, and for up to 3 months following the birth of a child or a miscarriage. So I wasn't aware of this provision until I was preparing for this presentation today, and that does give a pretty good right to educational services at home or hospital for young mothers. It can also be provided on a split time basis, meaning that the child may be able to attend school for part of the day and not the full day, and so they may be eligible to receive some services at home and some services at school. And as you'll see in a moment, sometimes schools say, well, if you're able to come to school for any period of time, then you're disqualified from home hospital instruction. That isn't consistent with the statute, and we would regard that as being not consistent with the school's legal obligation. Schools can provide home instruction through virtual instruction. That's something that was more infrequent prior to the pandemic, but is now obviously readily available. But the law does say that if a student is getting home instruction and the school wants to provide virtual, there has to be at least 2 hours of direct non-virtual instruction per week. So there's even with the very limited floor of 5 hours a week of overall service, if some of it's going to be virtual, there at least has to be a couple hours of direct, unless the doctor says that the child has to be medically isolated and can't have someone come and visit. So, for example, if the child has either a contagious disease or is immunocompromised, and it would be contraindicated for them to have people coming into the home to provide educational services, then they could qualify for full-time virtual or for all of the education to be virtual in any event, not necessarily full-time. If there is summer school provided for everybody and the child would qualify for summer school otherwise, then they can qualify for home hospital tutoring during summer school. So there's no limitation that says that it's just during the regular school year. It can be extended to summer as well. But, and it may be obvious at this point, but schools are not required to provide home hospital instruction for students who are not enrolled in the district. So what I'm talking about when I talk about homeschooling, that's a different category. In order to qualify for home hospital instruction, the student has to be enrolled in the school district, and then they're entitled to services if they're medically unable to attend school. Then, if a child is needing to be at home for some short period of time, that's particularly, let's say it's the child has an IEP, but they break their leg in a ski accident, they would be entitled to homebound instruction, and they should be getting some modicum of special ed services at a minimum while they're on homebound instruction. But that's a temporary non-IEP driven home hospital instructional component. So there's no reason to change the child's IEP unless there's a determination by the IEP team that the child cannot attend school for an extended time and it's decided that their placement needs to be at home. So if the child is medically unable to attend school again for some non-disability related reason, the IEP team should consider the medical limitations and what special ed and related services should be provided, but they're not automatically obligated to provide full special ed and related services to that student during the time that they're at home. Then, and this is where it gets particularly involved, if a student can't come to school for extended periods of time or intermittent short periods of time that are anticipated to be present on a regular basis due to a condition that's caused by their disability, whether it's a physical or emotional disability, then there can be something called a homebound IEP. And a homebound IEP is in effect an IEP that says that the child's educational program will be delivered at home, not at school. The homebound IEP must consider the medical condition, including the diagnosis, its impact on the child's ability to participate in education, and the child's anticipated duration of absence from school, warranting the provision of the homebound IEP. So that's a potential mechanism for kids who have chronic fatigue syndrome, severe anxiety, emotional and behavioral disorders that make it hard for them to attend school, severe allergies, kids who are immunocompromised, kids who have other severe medical conditions that make it difficult or impossible to attend school. And we've seen an increase in the number of kids who need homebound IEPs since the pandemic. And indeed, there are two different ways that that shows up in my experience. One is that there are a lot of kids who are immunocompromised, who may not be able to go to school due to the risk that they'll get in, some exposure that would be medically problematic for them. But the other is there are a whole group of kids who have anxiety disorders who got basically severely anxious about the potential for being sick or getting sick due to the pandemic and due to COVID-19. And there are still kids who are struggling with those sorts of issues, even given that it's been now several years since the pandemic has gone into a less serious form. So if there's a need for a homebound IEP, all of the normal mechanisms for revising an IEP have to come into play. There should be an IEP meeting with notice given to the parent, full right of the parent and their clinicians to participate. There has to be discussion of what the child's needs are, what the goals will be, what the accommodations will be, and then what the services will be. Again, there's a floor of services that the district must provide at least 5 hours a week of instructional time for the services that the child needs. Okay, so there's a question, when might schools consider home hospital versus therapeutic school placement? That's a good question. Sometimes a kid is unable or unwilling to go to therapeutic day school either. They don't necessarily need, and it would be inappropriate and too restrictive to send them to residential, but they can't leave the home. I've had kids who were not only unable to leave school, leave their home to go to school. I had one student where he wouldn't leave his bedroom other than an occasional meal. But other than that, he stayed in his bedroom all day and all night. And he needed to have a homebound IEP in order to meet his educational needs. Now, ultimately, he did transition to go into a therapeutic day school, but there was a period of time when the severity of his mental illness was such that he couldn't go to school anywhere, whether it was a public school or a therapeutic school. So the district has to provide a minimum of 5 hours a week. Again, my experience in the real world is that most districts interpret the idea of a minimum of 5 hours to be a ceiling of 5 hours, and that's not correct. And this we'll see and talk about in a few minutes. There are a number of cases that have addressed the school district's obligation to look at the individualized needs of the student rather than to just have a mandatory cutoff or an arbitrary cutoff that says we just do 5 hours and that's all that's available. School districts are required to provide educational services and related services to kids who are on a homebound IEP by staff who have the right credentials. So if there's a service that requires a special ed teacher, then it's supposed to be provided by a special ed teacher. If it's a therapy service, it's supposed to be provided by a therapist who's credentialed by the state board to be providing that therapy service. There is an important case that was decided in 2021 by ISBE that found that most of the issues that were complained of with respect to the CPS policy on home hospital instruction, CPS was violating the law. So they said that the CPS policy of restricting home hospital to after-hour services did not violate the law, but they said that CPS improperly placed the decision on home hospital services with an administrator rather than the IEP team. They said that the provision of related services was minimal or non-existent, and again, not based on the child's needs, that they improperly limited the home hospital services to 5 hours a week and placed a cap basically on the amount of services, and that they did not have a mechanism for providing compensatory services when services were missed. So there's a very strong precedent for the fact that more robust services can be provided through a homebound IEP if that's needed. Okay. There was a case about 14 years ago in the Seventh Circuit that did make clear that the medical certification that's provided indicating that the child can't be home does not trump the school district's decision-making and the IEP team's decision-making in relation to what's appropriate homebound services. So the medical doctor may say that the child can't go to school, but the medical doctor can't describe or define for the school district what the educational program must be. They can't control what the school does, but on the flip side, the school has to provide consideration for the recommendations of the private clinicians or doctors. So there's a balancing act there between the school not automatically having to do what the school says, what the doctor says, and on the other hand, not being allowed to ignore what the doctor says. So again, minimum requirement of 5 hours, but the level of service may be much higher. Can't mandate what the services will be, but that must be considered. And we've had a number of homebound IEP cases where we've gotten more than 5 hours a week of services, and in a very tough case, tough for advocacy purposes, tough for the family. Particular family we represented had 3 children who all required home hospital-based homebound IEP services, and we were able to get the 3 kids, all of them, a full 30 hours a week of educational services, including instruction and related service professionals coming into the home. So that's unusual. It's hard to do, but I'm describing that case just to emphasize the fact that the 5 hour a week limitation is not legitimate, and you can get a lot more than that. Specific provisions in IDEA, the regulations relating to homebound IEPs are indicated here, and the slides, by the way, will be posted on our website probably by late this week or early next week if people want to see a copy of the slides. Homebound instruction may be necessary for a student with a disability who is unable to attend, again, for medical or psychological reasons. My experience is that it's very useful to have clinicians who are not doctors opine about the fact that a child has an emotional problem, anxiety, whatever the problem might be, depression, or other behavioral problems for that matter. But in order to trigger the homebound IEP from the parent side, you generally need to have an MD, and to trigger the homebound IEP, homebound medical services, you need to have an MD. On the other hand, school districts sometimes decide on their own that a child needs a homebound IEP, and they don't have to have a medical doctor doing that. They can decide that that's necessary for educational reasons using all of the multidisciplinary team on the school district staff with the parents in deciding it's appropriate. And we do have a number of kids in any given year where the school says, we can't figure out anywhere to put them. We'll send them home with a tutor. And that's in some ways a little bit like the boy putting his finger in the dike trying to hold back the ocean from flooding in. It's often barely enough or not adequate to meet the child's needs. Again, the IEP team decides whether to place a student with disability on home instruction. Home instruction is not appropriate when the child's needs can be met in a less restrictive setting. It's debatable in my mind whether a homebound IEP is the most restrictive or a residential placement is the most restrictive, but in any event, it's right up there as being among the most restricted placements that can be offered. And so we have to be clear that if there's a way to serve the child in a homebound situation, but he could be served, he or she could be served in the public school with some level of appropriate support, that's the better and appropriate way to go. Homebound instruction should not be used to avoid a manifestation determination review or disciplinary process. We have this come up often where the school says, well, you have the option of either expulsion or therapeutic day school, or maybe the option is expulsion, therapeutic day school, or homebound IEP, or sometimes it's just expulsion or homebound IEP. And that's not an appropriate kind of choice to give to parents, certainly not without full parental input and a determination that there's no less restrictive means to meet the child's needs. The only circumstance, this is somewhat of a tangent into disciplinary discussion, but I do think that there are times when a student is facing potentially severe discipline and at worst even expulsion or transfer potentially to a very undesirable therapeutic day school or alternative school placement, where we sometimes will negotiate with the school. If the parent keeps the kid home for 5 or 10 days while we're problem solving, even 10 days, even a number of days beyond the 10-day suspension, if that will allow for things to get worked out in a way that spares the child either the expulsion or the placement in the undesired alternative or therapeutic school, that can be a positive thing. But you don't want that to be open-ended, because then the parents are stuck with dealing with the child's education when they didn't really want to be, and the school is just saying, it's your problem, we're not going to deal with it. It should only be when that has a constructive purpose and is time limited in helping to resolve the problem that will allow the child to return to school. The special ed law IDEA does not require home instruction IEPs to provide exactly the same amount of services that the child would have received when they were attending public school. So it has to be adequate, but it doesn't have to be numerically equivalent, and it has to be based on the child's unique needs. The school district is required to provide a continuum placement, and as I've indicated, it should only occur when there's no less restrictive option that can meet the child's needs. The decision-making authority is with the team, including the parent. The team has to consider the opinions of the private clinicians, but they're not bound by them. And they must ensure that the provision of all classes, services, and modifications is based on the child's disability and individually tailored to meet their needs. They don't have an obligation to provide non-educational services to a student. So, for example, the student who's on homebound might not be able to participate in certain extracurricular activities or those sorts of things. We've fought with schools about that too. It's intended to be a stopgap measure, not a permanent placement. And it's not available just because parents decide that they want to keep their child at home. You have to be able to provide a disability-related basis if the child needs to be at home. And if the school's disagreeing, you have to provide clinical support for why the child needs to be at home. So the case law on home hospital is not highly robust, but there are some cases that have considered it. In the Cedar Rapids School District case, Supreme Court said that districts have a requirement to integrate students into the school environment to the extent possible, and homebound instruction should not be used to deny a student a free appropriate public education or services in the least restrictive environment if there's a way to feasibly and adequately include them for part or all of the school day. Supplementary aids must not be sufficient to meet the child's medical needs at school. So in other words, you should only I don't really understand what was meant here. So basically the point here is that if there's a way to accommodate the student with supplementary supports in school that would address the medical needs, then putting the child on a homebound IEP is not appropriate. And as indicated, it's not up to the physician, it's up to the IEP team, and the medical statement, it doesn't define by itself what the homebound IEP should be. Parents shouldn't be allowed to decide that they want the child at home just because that's their preference. That would be a violation of FAPE, as well as if the school decided the child should be at home when they don't really need to be. And it's important there to be clear, and many of you may be fully aware of this, but parent preference doesn't automatically equate to what the school's obligation is in relation to free appropriate public education. So there is consideration of parent concerns, obviously, is legally required, but the only control that the parent has in relation to FAPE is to either withdraw their child from special ed altogether and just enroll them as a regular ed student. That's a protected right, or to request mediation or due process if they disagree with the services that the public school is offering. Nothing in the IDEA requires a district to provide a student with a full day of homebound instruction or to provide exactly the same amount of special ed that they would have gotten in the public school, though I've indicated, and we'll share a couple of other cases where it was held that what the school district was offering was insufficient. These are all examples of cases where the school district offered the minimum 5 hours a week, and the state agency or the court determined, nope, that's not good enough, and you have to provide both an individualized determination, and that based on that individualized determination, it could be more than whatever is the minimum that's identified by the school's policy. Districts must ensure that the homebound services are provided to students are as effective as the services that are provided to non-disabled students. A district that offers the number of hours required under state law may not meet the standard. And there's some, again, administrative agency and OCR decisions that support that, including anytime the school district just offers, this is our package, this is what we do, and we do it for everybody. That sounds non-discriminatory, but actually it's not individualized, and therefore it is discriminatory. Violations of 504 can also occur if a student is not given an appropriate level of homebound services. So this is something that applies not only for kids who have an IEP, but also kids who either have a 504 plan or have a disability that perhaps should have qualified them for a 504 plan. And the school district can't use the fact that they don't have enough staff as an excuse for not providing homebound. It's their obligation to provide an adequate level of homebound service. And it's supposed to be based on what the child needs, not based on what they have available. And importantly, if they don't provide the services that the child is entitled to, then they may be legally obligated to provide compensatory services. And you can see on our website, we have a bunch of different webinars on comp ed. That's intended to make up for services that the school was supposed to provide, but failed to do so, whether the reason is a lack of staff, a lack of motivation, or whatever the other reasons might be. But the point being that if the school doesn't do what it's supposed to do, then they're supposed to make up for it later. Okay, some key takeaways. The free appropriate public education mandate requires IEP teams to develop homebound IEPs that address all of the students' unique needs. The school has to provide the resources that will accomplish this, and the home IEP is LRE only when there's no way to meet the child's needs in the public school setting. Okay, so that's the outline. These are some resources that are available online, and citing some of the cases that I cited are listed here as well. So as I mentioned, this will be available online within the next few days. Okay, any comments, questions, reactions? All right, well, in the absence of any comments, if any folks have questions later, feel free to email me. My email is matt@mattcohenassociates.com. And oh, here we have a couple of questions. All right. Question from Robin Simpson. Our freshmen received 5 hours of homebound and Wilson reading and math. How can we apply towards graduation? We need homebound for next year. Can we do a homebound diploma even if he returns? I've never heard of something called a homebound diploma. I think the child, if they meet the school's graduation requirements, they get a regular diploma. If they don't meet the graduation requirements, then you've got an issue that you may need to fight about or work out with how they're counting the work. Because generally speaking, the homebound IEP should be designed to allow the child to stay on track with the credits they need to progress towards graduation. Okay, then there's a question, an ongoing issue with schools trying to force medically fragile kids into either homebound or virtual because they don't have one-to-one nurses. Do you have any suggestions for handling this? That would be a question that you might file a complaint with the Illinois State Board of Education about, because they're not supposed to condition being at school on the availability of staff. They're supposed to provide the necessary staff for a student to be able to come to school. If a child attends school to access schoolwork for 30 minutes, does that void the hour per day? No. The point here is you can have a hybrid, and the determination of what a child needs is not supposed to be based on a formula. It's supposed to be based on the student's personal needs. Okay, good. I hope that was helpful to everybody. And can a homebound student go to school longer to obtain a diploma when he returns, maybe in place of or with transition? If a student's disability requires them to attend beyond senior year, or their needs have not been met by the time they're either done with senior year and they're 18 more or less, and they've completed 4 years of high school, the fact if they don't have enough credit, that could be a reason to continue beyond senior year. Or if they have educational needs as reflected either in their not meeting their goals or in goals that haven't been able to be addressed because there wasn't enough time. There are many different reasons a kid could continue beyond 12th grade to get further services to be able to graduate. So the answer to that in my mind would be yes. Okay. Well, thanks everybody. Good luck, and hope to meet again.